To Jnanavarthini, FDPPI's weekly knowledge session. Today we have Mr. Abhivardhan, who is a technology law specialist and AI governance consultant. He's also an entrepreneur and author. Alongside his consulting and policy advocacy, he has been involved in both authoring and editing books, focusing on public international law and its relationship with artificial intelligence. He's managing partner of Indic Pacific Legal Research. He's also the author of India's first privately proposed artificial intelligence regulation, AIACT.in, which he is going to present to us today. Welcome to FDPPI, Mr. Abhivardhan. Happy to have you here. Over to you.
Thank you so much for the delightful introduction. I hope I'm audible now.
Yeah.
Anyways, so thanks for the introduction. So I think this is perhaps the first session outside my own forums or anything where I'm talking about AIAct.in. So again, it's a pleasure to have, thank you for having me here. So let me briefly talk about AIAct.in before I delve into its portions in this presentation that is visible to everyone. So AIAct.in by all means is actually one of the first, or maybe the first proposal, at least for now in India, which kind of is developed in a way, and the longer name, because AIAct.in is like the domain name or, the acronym of it. The larger name is what I call as the Draft Artificial Intelligence Development and Regulation Act. And this is again taken in a more common law terminology as it happens in India, UK, and other countries. If it were an American context, I would have taken a more attractive name, but I think I'll keep it like that. So in that regard, when we look at AIAct.in, what it is exactly. So it is a draft act.
Mr. Abhi, who are all behind this particular proposed draft?
So I am the author, but feedback has been taken from different stakeholders whenever a version has been published. So yeah.
Okay.
Yeah. So when we look at this proposal, the more interesting aspect around it is how why it is important for the rest of the country. Why should we talk about it? So AIAct.in in a way is a proposal which kind of helps you to understand that if, for example, a statute which could come on AI or which could be potential regulation, then in an Indian context, how would it actually work, or what could be the potential implications? Because for all the cheesy statements and for the interesting stuff talking about, this much $1 billion or $1 million AI will contribute in India, AI is still a nascent industry in India in terms of its research and development. And from a strategic and ethical point of view, I think we as Indians will leverage a lot from AI. We are already trying to do it. Legal tech or not, we already are trying to do it in manufacturing. We already are trying to do it in entertainment and creative economy and other things, and even in education. Not exactly edtech, but other education tools, because even in other aspects, it's hard. And yet I'm not even talking about generative AI. I'm talking about general AI, which we already have. So amidst all the hype, whether AGI is coming or not, whether AI is going to be a big $1 billion industry in India, at least we know the fact that anyone at the level of a research lab or a local engineering college is going to build an AI, and there will be regulatory concerns all around. For example, just the recent general elections have passed on, and we already know that the use of deep fakes has been mainstreamed across. I'm not getting into the details as to what were the incidents or who was responsible, who was doing it, but we all know that the use of deep fakes was mainstreamed, and that is the fact. Now, this draft has a lot of sections and a lot of parts. So this PPT, which I'm showing you, kind of makes it simpler to understand as to what were the portions, because the first version kind of came in just after this India AI expert group report was published by METI. And that was a response to that report in a positive sense, that there were some amazing aspects in the report about skill capacity building when it comes to AI in India. And it was a very interesting time because it was like October 2023, and we kind of saw the thing that, you know what, the Bletchley Declaration came in from the UK, AI safety, frontier AI. The Biden administration, the US government came up with its own executive order, which actually has been implemented pretty well with good timelines. So everyone was panicking basically, right? AI just became the thing which is just so important for everyone. Now, for a country, for a global south country, for an Indo-Pacific country like India, I think we really need a clarified approach to AI regulation, which is why this proposal was drafted. The first version came on November the 7th, 2023. The second version was published on March 14th, 2024. And the third version was published just a month ago, literally, maybe if we can say, 25 days, 26 days, June 17th, 2024. So let me now go through certain basics. As I said, it's about a regulatory understanding so that we see as to what can be regulated or standardized or legalized and what cannot be legalized. I think this is a very important question which was needed to be discussed. This is about me. I think that's been already said, so I'll just skip this one. So the first question which was important to address was about classifying AI. Because the problem is with any class of technology that will evolve, whether it is blockchain or AI, we will have to see how we will even classify them. And in my view, like in intellectual property and trade, we already have standards like standards for registering what is a good or a service under the DPIIT, or maybe for patents and trademarks, how we register a class of service or a class of product or good. The same can be done in the case of AI, but in a different context. Because if you're registering a solution or a use case through a company or a proprietor, that's a different thing altogether. You're doing an Udyam registration or you're doing some other registration, or you are getting certain intellectual property recognition. That is a different matter altogether. But a more neutral and legal way to do so is something which we have tried to address. So that's what I propose, that there are 4 ways to classify AI. They are kind of highlighted here. So these 4 methods are interesting because some of them are substantive law based, where you have certain substantive understanding to develop, and some of them are more procedure related. For example, the one thing which I've clearly inspired, but it's not exactly a copy, it's more of an inspiration from the European Union AI Act, is risk-centric classification. Because for any country which is a developed country or a developing country, at any level, risk management is a very big issue. For startups and research labs, it's also a big issue. So if whatever AI are you building, at least as a technology person, you should have some risk-centric measure as to what risks are you understanding and what risks can you handle. So the European Union Act kind of gives 3 classifications: narrow, medium, high, and narrow, high, and unintended. I have given medium as one more, as an intermediary between the narrow and the high ones. And there are some similarities from the European Union Act, at least in the risk part. But the rest of it is completely original in its own way. For example, when it comes to the first classification, section 4, it's more of a substantive law classification which can be used in matters of intellectual property law, knowledge management, contractual issues, and sometimes even self-regulatory aspects. For example, companies. So there has been news since 2010s. In 2016 or 2014, a board of directors in a company in Hong Kong, I'm not sure if they were publicly listed or not, they decided to put an AI system at the level of the board of directors in terms of their confidentiality. Now, again, a company can do that. It is their business decision, their internal management decision. But when you're putting an AI system to that pedestal, people will generally say, oh, AI will be a legal entity or something like that. Well, I don't think so. Maybe the company put it for a reason that, you know what, they found some substantive reason that there's some confidential insight coming up. And we just want to keep the processing, or basically the input-output cycle of AI within the reach of the board to some level. That basically the level of confidentiality they wanted, like what happens in a government, that like you have protocols that, certain bureaucrats cannot access at certain level. Therefore, that's a basic thing. So maybe for confidentiality protocols, maybe for certain hierarchies to create, substantive law sometimes plays a great role, and sometimes certain principles of company law might play a role or not. So to address that, these substantive classifications have been there, like issue to issue, ethics based. So they are simple. Issue to issue is like sometimes an AI system's substantive features. So the whole idea is based on a simple definition, which is known as inherent purpose. That is already defined in the definitions clause of this act, where I have kind of said that every AI system, when is at an application level. Now, it's a different issue if it is monetized or commercialized or not. I'm not getting into that. But even if it is available for free or testing for a select clients or people who could be the business end user or end user, the AI system itself will always have certain use cases or test cases that will exactly define its inherent purpose. And a research lab or a company or a person building AI will always know this. For example, if I'm building a facial recognition app or maybe a biometric app saying, you know what, okay, I'll just have your thumbs and something like that. You have to scan it through my camera and I will try to help you understand your health issues and whatever it is. Then the person who is taking the data knows that the person is actually taking over a lot of sensitive information and sensitive data. That is the biometric data, right? It could even apply in the case of other things, maybe in e-commerce and other things. And I think when you're taking it, sometimes from a substantive law point of view, and even a commercial, because a lot of aspects are contract based, right? And sometimes even based on market practices. So everything might not be codified in law exactly, but we have to know what's happening in the market. That's how also a lot of MNCs in the US try to take advantage of Indian consumers and Indian businesses. Sadly, that's the case. That's why the digital competition bill was proposed by a very established committee of experts in the field of competition law and corporate law to the government of India. So substantive law issues are a lot of there. They're very, either they're like tort liability kind of issues, or they're very, very substantive enough in a sense that they can't be easily drafted. So it's better to keep a documentation and understanding what they could be. So issue to issues like, what is the issue? An issue specific focus could be there. Then beyond that, there is what we call ethics-based concept classification, which is basically a phenomena basis aspect as to what kind of legal and economic rights could actually emanate or emerge from a particular transaction or from a particular action when it comes to an AI. The third one is more about phenomena, which is based on what is a general trend which is viably understood, not exactly based on a causality, but based on a larger policy phenomena, which can be recognized for better adjudication or better legal review. So that is again an evolving aspect. And again, the section 4 part of this act has not been completely, I would say, covered in every other major section. But again, in certain aspects of intellectual property and deepfakes, the certain references have been given. And the last one is anthropomorphism, which is basically saying that, so a lot of debate goes on that AI systems have the feature. So AI systems can basically mimic humans, right? That's the scientific logic given. So it was an interesting point. So I thought, okay, let's at least quantify what could be the human attributes like perception and other things. So that has been provided explicitly in one of the sections, of course, which is section 4, of course, that what could be the anthropomorphic, which is to say human copying or human imitating features. Now, technically speaking, the human imitating features are repetitive and they're not even human features, because what I can do, what people in the audience can do, an AI system is not up to that. It's just that things like Gemini and ChatGPT make us feel that they're very good in perception. That, you know what, they understand everything that we say. But turns out it's just manufacturing of consent. It's just like, it's made to answer certain things because it is trained on that. It doesn't mean that it's accurate, or it doesn't mean that it is just like an absolute perfect thing that it will just learn on its own. So that's why anthropomorphism is important from a psychological point of view as to what could be manipulative features. This could be used in aspects of cybercrime, maybe later, or maybe something like that. So this is basically kind of section 4 is basically the back end in terms of substantive law. Section 5 and 6 and 7 more are procedural. Like section 5 is more about technical distinction of AI from a perspective of use cases. First one is simple. For example, you have like a chat GPT, which can help you in so many things. For example, building an itinerary for your visa application, people do that. Or unfortunately, some law students have tried it. So I'll also say creating a template for an appeal to the income tax appellate tribunal. Of course, you can't use chat GPT for that. You can't trust these tools, but people created it. Or maybe an arbitration application to a relevant high court. Well, you can do that through ChatGPT, but it's not like a complete tool which will help you. You still would have to fill details and find the mistakes and all that, right? So OpenAI and all these companies may say that, you know what, we might have certain stable use cases, like a chatbot which can help you on certain things like mathematics queries or understanding physics, at a high school level or something like that. So for that general purpose AI with multiple stable use case, because general purpose AI is a terminology taken by OECD and the European Union. So this is the terminology which I've made similar so that there is no confusion. The second one is also the same, but we can say that, there are certain use cases which are not stable enough, which are not clear enough, which still require some documentation or proofing. And that is again a hard job, that because a lot of companies just come up with all these tutorials at a lab testing level and demos, but when they go out in public to a customer or a bank or anyone, or maybe a business user, they just fall apart. They just don't work. So the demos were good. All the YouTube videos which were featuring the demos were good. But when practical use was needed at an end-to-end level, maybe openly or not, it did not work. Third one, I think, is going to cover most of the AI solutions in India, which is specific purpose AI with one or more standalone use cases, which is like genuine technology. For example, in robotics, or for example, robotics, there's a company called Orangewood Labs. Obviously, we have companies like Zoho in Tenkasi, in Chennai, and Bengaluru, who are actually also developing AI solutions. If we have to count others, we can take other companies as well. Their use case is not that broad or large, or more just like a chatbot, like a copy of it's taking up third-party API, but more like having a specific use case. Then there are some education related startups, not edtech startups, who are also developing, and I've been kind of in talks with them also. So these are specific purpose AI as well. Section 6 is more from a commercial law perspective, from an industry perspective, that if we have to classify anything as a product or service, what it could be. So that was an interesting challenge to handle, considering the generative AI hype. So a basic introduction is like, okay, AI as a product is like a product, a unitary product. For example, Apple offering all these large language model features to every single iPhone model now is basically productizing something. But having a subscription of OpenAI ChatGPT 4.0 per month is basically a service, or SaaS, right? So AI is a service. AI as a component is more like integration of API per month. It could be like a service, but again, it's more of a component because you're using it for some other work, for CRM and whatever. So then you're using an API or a system like that. It's a component or embedded AI. So I have called it AI component. AI as a system is more like about system infrastructure of AI at various levels. So that is AI as a system. AI enabled infrastructure as a service is basically infrastructure, but in a more integrated way. We can say it's a system, but it's exactly not, because again, it's like a nested loop. So there is level 1, level 2, level 3, level 4. Something is happening at level 4 because of which level 3 is being helped. Something is happening at level 3. So a distinction was needed, so therefore. But the last one is more interesting, which is AI for preview. Because in AI for preview, what happens is that you're actually going to see that there are a lot of AI companies are going to offer you a lot of freebies. They're going to give you these free access to AI tools or limited access to AI tools. And they're going to say they're not commercial yet. They are not products yet. We have a free research preview for a limited time. So I was like, okay, this is a new approach to or to understand. If that is the case, why not give them a specific classification? AI for preview, saying that, you know what, you might not be exactly commercial yet, but again, you are getting user feedback, you're trying to get customer feedback, client feedback, which is normal. So that is again, Gemini comes in sometimes, OpenAI comes in, but I think considering the monopoly they have, considering the capital they have, I don't think they should be pardoned with such thing. They should be categorized as AI as service or product. But again, that's a different debate. It should be the Indian startups and MSMEs and others who actually are trying to thrive, who should be suggested at AI review. And Section 7 is very kind of similar to AI Act of European Union, but not exactly. Because narrow risk, medium risk, high risk, and unintended risk are more about what are the specific risk levels which are understood on the basis of outcomes and impact. That if something has happened or something is poised to happen, what it could be and what could be the after effect of it. So the risk classification is based on that aspect. The last one, of course, unintended, is just ban it, that kind of system. And narrow is more into smaller use case, smaller purpose, smaller impact. Medium is more like it's getting to that edge and it has, but it is not high risk still. Again, it's a sector question. There could be a sectoral aspect, right? Like, for example, in healthcare, you have data, biometric data of children, or I don't know, some other sensitive information of, people of a particular demographic, of a particular identity, whatever. How are you using it? How is the hospital processing it? How is the pharmaceutical company, if in partnership with, using it? So risk emerge of use of data. It starts with data. It goes with algorithmic functions. It goes with anonymity and all those problems. So this classification and risk is given. So now, once classification is done, the question was how to register. So sections 11 and 12 kind of address that. We say, okay, we register AI use cases, then we certify them. Now, in my proposal, I have not said that everyone should register their AI, because again, in the name of making it everything mandatory, a lot of non-qualifiable stuff also gets registered, and then we don't know what we do with all of the data. That's the problem at the level of the Ministry and Department of Statistics and all that, at the Government of India, and even at the state government level. People have too much data, but they don't know how to leverage it or use it. Sometimes even the Niti Aayog has these problems and they address with them. So registering is voluntary. Certification is also voluntary, but for high-risk systems in India, be it in health, be it in education, be it in pharma, be it in any other field, maybe even in energy and transportation technology, they kind of could be high risk. And registering their use cases, maybe a recommendation algorithm or a generative AI, because both of these are different things. Generative AI creates something new in our perception, while recommendation analyzes existing content and portrays it in a very harmonious and unique way. So both the things are different, they're not the same. So registration is necessary. And then Section 11 establish a voluntary certification scheme. But the interesting part, which I actually wanted to focus before I go into other parts quickly, is registering AI, which is about exemptions from certification. So in the narrow and medium risk category of AI, there could be certain systems which could also be AI pre, which is AI preview, which could be in early development stages, which could have highly specialized operations, or they are developed by startups, small enterprises, or research institutions. So this is one generic statutory exception or legal exception, let us say, I have given in a way that if there is a startup or a SME, they should be given this leverage, but every single person who is building AI in India should at least be mandated to have some risk management protocols, or we call it incident reporting protocols. It is simple. Suppose I know somebody who's an engineering student in Chennai or Mumbai or I don't know, Delhi. And the person in a local engineering college is kind of developing an AI system, which is like a WhatsApp chatbot. And he's using generative AI with certain fine tuning to ensure that a customer gets certain important information about, where to travel and all that, local tourism and all that. I'm just giving an example. And turns out the chatbot is misleading the customer at a very, very high level. And it's misguiding. It's not as better about trivia, and it's forcing the customer, urging the customer to go to places which are unsafe or something like that. Now, if the app kind of understands this and there's some coordination, the person should have certain protocols saying, you know what, okay, we have this problem, we have this mistake, I'm sorry, you should be informed of this. Maybe the system is not that accurate, maybe the system has inefficiencies, but a customer's consent of even understanding matters. Because, the reason why science fiction and robotics is so popular in India is simply because, not in India, even across the world, is because we as humans believe that these robots and AI systems are kind of our own mirror image, which in fact is not true. Because again, they are technological beings, and not beings also, technological machines and things, and they're not perfect, they're evolving. They may be catered to our needs, but they're not exactly us. So considering that, this exemption has been provided to protect, and again, it doesn't mean that every exemption is given to startups and SMEs and research labs. This is a legal understanding that how it could be done, but this is the basic way to do it. Then, of course, there's a registry approach, which you can see that there are basic things to do. But the most important thing which is required for registration of AI, which I've proposed, again, I'm not saying that all of the AI Act itself can be implemented by a government or something. I'm not saying that. Again, this is for feedback purposes that, if registry happens, how would it happen? So, of course, that is there. As there are aspects such as name of a system, use case of a system, much more important. Commercial features can be decided. What are the technical features? Are you saying it's a viable use case or not? That is again subject to understanding. So again, that will evolve in future versions, but this is like a framework at least ready. Then this is a metadata scheme which is needed for registering AI systems in a way. And certain incident reporting protocols are mandatory for everyone because this is a basic somebody can have. For example, somebody can contact through mobile or phone or email or WhatsApp or how to avoid to inform certain incident that has happened or something else. How will the person do? So that I think needs to be addressed, which is why this is provided. And then we have certain basic aspects. I call it the DPSP of AI, in a way that it is basically a national AI ethics code about certain basic concepts about rights, privacy rights, non-discrimination rights, and due process, and how AI systems should be designed in a fair and non-discriminatory manner, ensuring equal treatment and opportunities for a country like India, where again digital divide still exists. Digital world enabled equality also exists. So considering that, again, the divide is there still. It's being held up. It's being tried to solve, but it's not solving that well. So considering that, these are basic principles which are non-binding, but they are kind of ethical in a sense that, okay, if we have to come up with a new legislation or a thing, maybe these principles can help. So this is like a core constituent, of this act in a sense from when it comes to concepts and principles. And these are some of the main points like fundamental rights, focus, transparency and accountability, which is more about corporate governance decisions and how you handle with clients and customers and government. Then safety, robustness, and sustainability. These are basic things. And intellectual property is the most important part of this, simply because a lot of question has been about what could be the specific IP ownership problems that can be solved. So right now, at least in this act, you will find how to create maybe a situation to manage it and then see what could be effectively recognized. I've not exactly given a substantive law approach to say this is exactly should happen, that where AI will be an inventor or not. I'm not getting on these debates. I think they are subjective. There should be a very objective approach to this, because an AI can't be an inventor simply because an AI does not have the consciousness to do so. No AI system in the world can do it. Even with quantum tech right now, there is no scientific proof of it. There is no research proof. All these big companies just hype about it. So it's better not to agree on that. So scientifically, there is no proof. Therefore, legally also, it makes no sense to say that AI can be an inventor. And one aspect is very interesting here, apart from many, which is guidance principle for contracts. So there are these kinds of contracts like service, software license agreements, and other forms of agreements like model licensing agreements, collaboration agreements. There's also one category I've introduced called as explainability agreements, which is to say that you have to, if possible, if companies want, of course it is voluntary, if companies want or two parties want, they should have certain explainability contracts stating how an AI system works. And if there will be certain problems, what could be the measures that could be undertaken for mitigating the risk and the problems out of the fact that the party developing the AI system and offering the AI system is not able to explain why this AI system is not working in a proper way. So explainability agreement, I think, is a very important thing in future. I think a lot of agreements on data sharing and all those things will also rely on explainability clauses or explainability agreements separately. And this might invite commercial mediation, or I don't think if arbitration will be invited, but at least commercial mediation can be invited. So that's definitely the thing. So these are guidance principles on AI related contracts. All of this is available on aiact.in. That's a domain, that's a page you can go. These are another guidance principles from inspired from the AI ethics code, again non-binding, but part of it is applicable to things like high-risk companies. For example, there has to be clear accountability about the use of AI techniques, because a lot of times what happens at multiple levels, especially in bigger companies, AI tools are being used, but it's not properly being documented, and then the after effects come around. For example, everyone must have heard the whole Gemini controversy, right? The whole thing with Google, that Gemini was posting something which was quote unquote inappropriate and all that. I'm not getting into the content part of it, but why did that happen effectively? Why did Gemini by Google fail? Despite Google having some of the best research labs in the world in AI, Google DeepMind, doing even better than OpenAI in terms of its research, not outcomes. And Google having, I think, so much data, like from YouTube to Maps to Gmail to everything. And yet Google has failed. Why? So the reason for that is that the employees at their own level who were handling the AI system and fine-tuning it, they did not take into, and this is reported actually, they did not take into account the sensitive realities of how things work. And they just put anything, they did not do appropriate fine-tuning. Sometimes AI systems actually produce something which are based on technical biases. And technical biases sometimes could reflect socioeconomic biases. But these employees were not taking care of it. And that's why this botch-up happened. And Google's reputation was heavily tarnished. Even in Google search, while Google search is still working okay, the Google AI search is not working better, because the Google AI search gives you, for example, in when one prompt it said, so somebody asked, how many years is the year 2022 ahead after 1919? Now, a common person could have said 100 years or more. Now, the AI says in Google 1919. Sorry, it says 3 years, which is funny. It should have said 103 years or something like that. Like, because 1919 plus 3 is 1922, but it did not say that, right? And a lot of these hallucinations and problems happen. So I think it's better that companies which can handle this, not emerging startups which have to work hard for funding and everything, but for bigger companies maybe, because again, this is a model which could apply in the whole world or India or something like that. It depends. So companies have to be clear about it. Then there is transparency and explainability, and it's more about contractual aspects and documentation aspects around AI. So that is definitely the thing. So when we look at it, these three things were addressed in the corporate governance guidelines and guidance principles, that how ownership of intellectual property when it comes to AI generated content should be done, how at a layer it should be documented, and then how it should be justified in a way. I think certain understanding was needed. So I thought mere, aspects of transparency and collaboration are needed. For example, if a Hollywood movie company, like, I'm just giving an example, a company which makes films in Hollywood, bigger company like Paramount or Warner Brothers or Marvel, they just process all of their content, which they can do, they have the rights to do. But on certain instance, they're trying to mimic their side artists, and they're trying to create their clones without even hiring them, using their voice, but not hiring them, not even compensating them for their voice, or just giving them some penny and, saying, oh, you know what, there's no contract, nothing, go. So the problem happens is that in the original contracts, obviously these things can be justified and contract is a different thing. But just merely processing without consent of the artists or people who have created some intellectual property, it would apply in other fields as well, even in the case of patent law. While patent is a different thing altogether. that could create a lot of ethical and economic implications, which is why SAG-AFTRA strikes happen. Which AI was a major reason why SAG-AFTRA strikes happened. There were other reasons as well about lack of pay, and when these side artists and people supported during COVID pandemic in America, these were sidelined later in 2022. So strikes were bound to happen, and that's why they happened. But that being said, the point is that a sense of transparency and collaboration with stakeholders is very much important. And I think if we are really believing in an AI-driven future, AI-driven growth across the world, I think we should accept to this maybe later. Maybe we should need more simpler approaches how to do it, but we need them. And I think that's why these guidance principles were proposed. This was, I think, kind of already told. So this was section 11.3 exemption about what AI systems should be exempted. Now you can see it on screen specifically, the subsection, like early stage of development, deployed or developed in a very, very niche applications, so that it's not even. So for example, maybe some banks are cooperating together for some very niche analysis about certain information. Okay. Now I'm just hypothesizing it. I'm not saying it in terms of the fintech regulations, but I'm just hypothesizing it. Or let us say two pharma companies partner together and they decide, oh, you know what, we have to analyze some AI content or AI information using AI. And again, it turns out that it was only for internal research, but it was not exactly that using sensitive data, or even if it was using in a way, it was consented in a way that the use was too limited. So if it is too much of a niche application or area, then of course it's an issue where certification may not be feasible even or appropriate, because again, it's not at a level that it should be done. So I think that is something which is a discussion that needs requiring, and maybe for version 4, I'm taking feedback from people. People can email us, of course, and I'll see what could be done. We also talk with our own stakeholders and people, so we'll see what could be understood in that. So this is section 3 exemption. And this is what it is, that early development stage, developer profile, and specialized applications. So this was section 11.3. Now, this is a very interesting one, which we call as the intellectual property provision, section 21. Because in this one, you will actually find aspects around how to recognize an intellectual property based, intellectual property of AI. So now we can protect AI systems to a combination of rights. For example, I will tell you that as of July 2024, actually early July 2024, I even came to know on the 7th or 6th of it. It was 4th of July. So 4th of July, Amazon has officially been granted a patent of natural language processing, which in my view is quite alarming, simply because natural language processing is a field in AI. It's not exactly like a process like GPTs, right? Or reinforcement learning, which is again a field. So a field of AI, can you really patent it? Because people who are in copyright and intellectual property know that you can copyright it, right? I mean, you can say, okay, we have published it at a date, we are the effective publisher, blah, 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 and therefore copyright matters. But patenting is a very huge implication. Patenting is definitely a superior intellectual property right as compared to copyright. So Amazon has done it, and again, that remains to be seen on what grounds they have been granted by the US Patent Office, the patent application. Why the patent has been granted, I don't know. Again, that requires to be analyzed, but this is very alarming. So elements of copyright, elements of patent come in. Sometimes even elements of industrial design come in. For example, in textiles or other things, you are using certain sophisticated AI techniques, or in pharma, you're using certain techniques, although generally patent rates come in, but I'm just hypothesizing. Or maybe in semiconductors, it turns out that you're using certain leveraged AI techniques for your chips. Then a combination of certain rights come in. Sometimes even aspects of TOT come in, right? Technology transfer rights, royalties, and all that, which may not be intellectual property rights, but it could also be taken in the context of trade secrets, like TRIPS and everything. So again, in that regard, it's still evolving. But I think if there were hypothetically an AI legislation in India, I think we should recognize at a substantive level what it could be, what could be certain aspects, how it should be measured. So I have done it from a lens of knowledge management, saying that AI systems have a sense of interoperability and everything. And uh, there are certain special aspects around AI which should be recognized. And the contribution of human creators has to be recognized in a statutory way. There has to be no ifs and buts about it. A company just merely can't say, okay, fine, we have all these developers working hard, fine tuning and everything. We have so much data accumulated, and this is too much hard work going on, too much money is invested, therefore it is proprietary. And since it is proprietary content, a lot of effort is going on, therefore it is our effort and not an artist's effort. Fine, it may not be. And part of it is that you may not even explain your choices sometimes. But at some point, certain aspects of compensation have to be addressed. Maybe not $5 million, for example, as an average, but something like that, right? Because everyone can't give compensation of that much amount, whether it's an MSME or a startup in India. We are talking about bigger companies in the US. So maybe bigger companies in India can do, but smaller companies in India won't be able to do. So compensation model at a civil law level won't work at a commercial law level. So I think that is an important aspect about IP management and IP recognition. This is again a very basic boilerplate provision that there should be consultative mechanisms. So yeah, but this is also interesting. This screenshot can only show you 4 of them. So I'll just quickly address that, which is knowledge management itself. So knowledge management is what? It simply means that you have certain assets, certain insights, and certain information with you, which you have kept it, which were responsible for the building of the AI system or making the AI system efficient enough. It could be any survey content. And again, I think if I'm right, there is the privileged information in the case of DPDP under legitimate use, it's already protected. I think it is, I can't remember, I think it's section 6 or something. It already protects against corporate espionage, for example. So even when we take the DPDPA legitimate use part, that section itself, that subsection itself in context, knowledge management covers survey technology results, intra-employee insights, other forms of insights among companies and places. So that way, a lot of such things are knowledge assets, because and sometimes even scientific outputs, which could be, or scientific inputs, which could be put, in research and collaboration. So all of that is knowledge asset, right? All those inputs and information that is created, that they might be relevant for justifying certain copyrights or trademark related rights, or industrial design or patent related rights. So right now, obviously, if you see section 14 subsection 2, you'll see that I've not referred integrated circuits or plant varieties or other forms of IP, because they're not necessitated here. These 4 are the most mainstream. Trade secrets are a commercial aspect which are different. It doesn't go to that level, so trade secrets have not specifically been covered, but indirectly trade secrets are also a part of it. So that's definitely a knowledge management perspective to this. And this is kind of an asset that technical documentation is important. There will be tacit knowledge, which could be recognized as a knowledge asset. There will be aspects around data analytics. What is the analytic content? So that needs to be protected. So all of that matters a lot. So that needs to be protected. That needs to be saved. That's what the management approach is. There should be some principles how we should manage them. I think that becomes important. One more point I've put, which is kind of different, which is knowledge discovery. Like, if you're using AI in knowledge discovery, sometimes it could be helpful in certain things. How it is being done? What could be the relevant responsible information sharing practices? Okay, so knowledge extraction itself using AI, that's an interesting territory, because data scraping exactly does that, right? These Perplexity and ChatGPT, basically they extract knowledge, quote unquote, or information, as we say, by searching whatever you want to. So that is definitely their AI-driven knowledge discovery. And ethical and rights-based knowledge management is more about recognizing certain individual right aspects, certain societal aspects, which are based on the National AI Ethics Code. So that is definitely there. One part we have kept up, which is for open source, which is very important, because in India, even if India stack has succeeded, despite all the privacy problems and data leakage and all those problems, like we have heard with DigiYatra and problems we have had with Aadhaar in the past, open source has actually worked in India. Open access has worked in India, and it has helped a lot of citizens and business end users in some of the best ways. Ironically, it is so sad that even a lot of people in the police, local police offices and all who do these passport verification, they don't even know that DigiLocker exists. So awareness is a problem in India, but beyond that, I think open source is a great thing. India Stack has succeeded, DPI has succeeded. So open source is a good way forward, because there are initiatives like People Plus AI and others who are working on it. So we thought, recognizing at a legal level that open source is good is necessary. So we have done that. Now this is a bit spicy aspect, because everyone discusses about it, deep fakes. Now deep fakes, the thing with deep fakes is, for any synthetic content, is in the text side of things, it's just nearly impossible to figure out, because unless it is some text for marketing and very basic, simple, creative communication where certain encoding can be found out as to, how the grammar format of a sentence it is. Plag, which is plagiarism using Turnitin and all these tools, can be done, which is again recommendation system. But even through generative AI, if you try to do it in text, it is nearly impossible. If you're good at grammar, you'll just make certain paraphrasing, and again, you can just automate it and completely ensure that in text you can figure out synthetic content, which is not human written. For images and videos, it is actually easy and possible. There are no viable tools. Even recently, Luma, which came in, an OpenAI Sora, they're not that good actually. They're based on very limited test conditions. So in open conditions where a consumer will exploit such tools for free or on a paid basis, these tools will expose themselves, and turn out they will be AI generated systems. They will be giving AI generated content which can be tracked by anyone. The risk which comes in with deepfakes is, how more realistic can it become? And how could it also manipulate our understanding of how, maybe, it could be used to manipulate biometric information or things like that. If it can do that, what can we do about it? I think that's where it comes. And a lot of it is within the domain of cybersecurity and cyber crimes. So watermarking techniques should be recognized. I've also suggested that we should have a national repository, maybe through Digital India program, or maybe something where we kind of keep a list of these forensic methods, both human based and technical based, so that we know how are we even designating them as synthetic content or deep fakes, as we say. Because if we don't do that, I think the problem will be we will never know. And again, lack of awareness is a huge issue in this country. So it's better that we know certain basic contents as well, techniques as well as advanced techniques. So having a documentation is very necessary. I have kind of suggested that it should be done through an open API. Again, this could be a guideline, so this part may be removed later. Again, this depends. But public accessibility of the watermark itself should be important. How can it be done technologically and how can cooperation be done is a different issue. But this is what I've suggested for deepfakes. And certification is definitely needed. But a larger important part with deepfakes was that when we recognize the role of deepfakes, the accountability for any synthetic content, as you see in the screenshot provided, the accountability for such something like a synthetic content should be based on a system's risk profile and its potential impact. And the risk profile takes us to section 7, which is all those 3-4 kinds of risk cycles and all that. So how exactly is it doing? You can find it in section 23, because again, we have an hour, I have an hour, so there's a lot to discuss. There are some miscellaneous provisions I did not wish to discuss. I've avoided them. They're just basic provisions like power to make regulations and all that. So again, I don't need to discuss that, similar to how it happens in other statutory documents. So I'm not discussing that, but I wish to keep it as specific on certain important parts. And this was maybe the second last part, which was incident reporting protocols, that how exactly incident reporting should be done. So for example, they must establish some mechanism. They should, high risk incidents should be reported in 48 hours. Low risk, high risk, why within 48 hours? Because that's a feasible timeline to generally do in a commonsensical way. 7 days is more for other AI incidents. For example, it's like a glitch or something like a minor thing, which is literally not causing a problem. It's maybe a narrow AI risk issue, a narrow risk, but it's not, it's a minimal impact aspect, which will have a lesser or nothing to like near to zero impact. So you can report it in 7 days. So the mechanism is very simple, saying that, this is what can be done. So this is definitely there. Confidentiality and data protection is of course there. That encryption, what is about encryption, how it should be done. You should have certain certificates for your websites and things. These are basic cybersecurity concepts which are applied. And then there are certain basic AI related aspects like audit logs of all data access. I think that needs to be maintained, that can be maintained. Then applying additional measures for high risk AI and optional measures for low risk systems. So these are the things which were proposed in the incident protocols. You can look at section 9 in detail. I think that would be more appropriate, because I think if I discuss everything in detail, every subsection, this would mean like 3 to 4, 5 more sessions. But I think I wanted to summarize. I think this is the last one, which is insurance provisions. Now, insurance is very important because for cybersecurity risks, insurance companies already help a lot at the level they can in India. Of course, I'm not saying that's an ideal way to do, but cybersecurity risks are kind of covered in their own way, like data breaches, phishing, and all those things between companies and individuals and proprietors. But when it comes to AI, uh, risk import is mattering a lot. So for example, for risk, again, these numbers are based on an understanding of how the government of India and relevant regulators like CCI, MeitY, and others, MeitY is a ministry, how they have actually covered certain coverages. So partly inspired from DPDP, at least on the numbers. Like if there's a widespread impact, of course, 50 crores is the coverage which should be given. If there's a vulnerability aspect or irreversible consequence, at least it should be 25 crores. If there's any other high risk AI, it should be 10 crores. But again, these are based on risk levels. These are for high risk AI. But the minimal for a high risk AI as a coverage requirement should be 10 crores, which is like an insurance requirement. Which again, I think most of the high risk systems will be either government based naturally, or they will be based out of MNCs and bigger companies, because again, high risk AI also is based on market coverage and risk. Market coverage in the sense how will it impact the target audience. So in that sense, I think these are the approaches. I think again, this depends. This can be changed subject to feedback. I'm open to take feedback on that. So definitely that's it. And insurance coverage has to be based on a risk level. And partly we should see their commercial features to understand how that can be designated. Again, that thing can be clarified better in version 4. I'm still working on it. It depends. I'm still taking feedback. Maybe in a few months, once the right time comes, I'll come up with the new version. It depends. But for now, I think some substantive and procedural features can be taken up. So this is there, and basic oversight and compliance can be done in collaboration maybe with the relevant insurance regulator, not necessarily with an AI regulator, which I have proposed. So that was it. So this is my final appeal. This is a draft act. If you have any feedback, if you have any points, please feel free to send us at VLIGTA, aka Vlicta, @indicpacific.com. I'll be more than happy to take your feedback. And it depends what feedback we may accept exactly. Again, that is up to us. But I'll try my best to incorporate the feedback wherever necessary so that we make it simpler for the kind of unsettled legal understanding that we still have in technology in India. I think we need a more clarified, because I got the feedback for version 2 saying that, you know what, there's a lot of lack of clarity around AI, this AI Act, that it's too complicated in certain things. And it's like, okay, let's try to blend certain features and see how it works in substantive and procedural aspects of law. And that has been the attempt. Thank you for thank you for being patient in this I think 1 hour monologue, if I'm right. But yeah, I'm more than happy to take questions, and please, yeah.
I didn't see any section on fines and penalties. When there was insurance, are you not keeping any provision for any fines and penalties, or in case of violations of certain guidelines or whatever?
That's a great question. So penalty is actually there. It's just not mentioned in the PPT. So again,
Okay.
when I show it to people in tech or data scientists, they might fear a lot, but I can specify which provision exactly covers penalty on the website. So I
Okay.
think it is
Okay, so it's there. Huh? Okay,
it's
fine.
there. It's there. You find. I think it's section.
Okay. Okay.
I don't remember exactly, but I think it is after section 25, something around it, which kind of addresses this.
Yeah.
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 Because it was a challenge. If we just give a very arbitrary penalty, it might not be encouraging, and sometimes
Yeah, but still something needs to be there for any misuse by organizations or something.
yeah, yeah, at least some basic penalty has to be there, and that is something we are trying to work on. Yeah.
And basic nowadays means nothing less than 4% of global turnover or something.
Yeah, so that part I think so when this third version came in, second version I was thinking to cover it, but when the day it was published, just the next day later, the digital competition bill came
Okay.
in the public. So version 2 when it was the case. So I was like, it has already come in, so we have incorporated some parts of the DCB on the turnover part.
Okay.
So in the insurance part, we actually referred to the section 3 and 4 of how to classify an SSDE. And the turnover part from there is taken. Maybe we can inspire some part from there, because again, it is just my hypothesis that if the DCB is passed in the parliament, aka and kind of accepted in a harmonized way, then we can see. Otherwise, we can think about it, because the DCB kind of covers digital competition law in a very first principle way. Questions could be about thresholds of coverage of a bigger company, but the numbers which were there in section 3 and 4, I did not find any specific issues. Maybe it can be discussed, but yeah.
There could also be some cases where because startups and labs are doing, there could be no turnover at all. But still
Yeah.
they come up with something which damages a lot.
Yeah. Yeah. So that's why I kept the market size part of it also there. But like, again, that needs a specific point and evolution. I think risk and technical features will define a lot, because a lot of companies just come up with anything in documentation. I'll give you a simple example. All of these companies have their access policies. Okay.
Right,
Like how
right.
this data will be processed and all that stuff. Beyond, if you go to these websites and Google and OpenAI, it becomes so hard to get through every single legal documentation they've provided. Like, nobody knows what is the access policy, how the fine tuning is being done, why it is being done. They're very unclear about it. So a lot of, I would say, ghost hiding of all the access guidelines and policies and bylaws is a problem. So that could be a legal risk, or that could be a bifurcation or fabrication of use case, which is why I think signifying a use case as a culture and commercial law is important, because that will define everything in a contract. And that could help us in mediation or legal action. That's why I kind of took use case as the basis of this legislation.
Okay.
Yeah. But I really appreciate the questions asked. So yeah, I mean, I'm open to more questions by anyone. I'm open to the discussions.
Hi, Abhivardhan. So it was really a wonderful session. So it's a great walkthrough. So I have a couple of things just to get a views from anyone of this forum as well. One, right, is there any body or authority has been set as a board to classify this high risk medium based on the evaluation? That's one. Second question is, any company, if they are starting in the small company, right, to open it as a startup, their group, if they even develop an high risk or what kind of an AI, first of all, what is the metrics to evaluate and categorize this? Kind of my understanding is silent and it is interpretable, right? The second, if it is a company which can be even a Google or any company where they can do a small startup company, they can open or acquire, when they get more vulnerable to these kind of high risk applications and continue to be calling it out as a developing phase, right? So
Yeah.
I may be seeing that this is a challenge where technically I've been facing in many companies. 2021 onwards they started, right? And similarly your preview portion of it, the classification, I think combination of brains works on this. I feel they take the data, though my consent is not explicit or a layering is maintained. They take the data, one, they get exempted and the preview part, so they explore it. Second, it has been running by the small company. Third, they maintain it as still in a developing phase. So multiple phases have been happening, and small one, they are bundling it for a commercial aspect, all that is happening. So how do you foresee this, one from an India perspective and global perspective on this?
Sure. So I'll just be very quick. So I think the Ministry of Electronics and Information Technology is basically the entity which is proposing a Digital India Act. Now, in that 2023 March PPT, which they had presented in Bengaluru in the UIDAI office, which is on their website, that was at the peak of the G20 presidency. They suggested that risk classification of AI will be under the Digital India Act. Now, again, when will that act come? What is the structure of the bill? I don't know. The PPT is very lucrative, though. It's a good back end to talk about, but I don't know about the front end, so I don't know. But on the second question which you have raised is very interesting, because when I read a recent criticism to the digital competition bill, and the criticism was that large firms who are trying to create new business models out of anything will be discouraged, and this could cause hampering innovation to India. So I'll give you an example. So you talked about consent. So so the whole safe harbor thing also comes here, right? For example, what YouTube is doing by processing some data out of Google search, these are two different intermediaries. YouTube is both OTT and social media in certain ways. Google search is an intermediary in search as well as ad tech, simply because of relationship with AdSense and the kind of coverage and knowledge graph it gives. The problem is when there is no explicit consent, they keep coming up with this excuse that we are still developing, which is again fine. But from a commercial point of view, they never clarify as to why. And then they obviously lawyer up in US, and everything is now based on a US Senate discussion or some hearing. Then we are at the mercy of the FTC to wait what's gonna come in their own district court judgment. So I think the thing is, we should not be right. I mean, this is something even a Singaporean would ask, somebody in Dubai would ask, somebody would ask in Japan and other places. So I think this is again, a lot of things are not clarified from a commercial point of view, because a lot of data sharing agreements and certain procedure related agreements happen internally. And that's why I think at least recognizing that these contracts happen and these practices happen was also an attempt in this AI Act, that at least recognize that if you file these contracts, have these things, maybe some voluntary aspect are needed, because I think it happens in other fields as well, right? In securities and other fields, it happens. There are specific contracts. Maybe templates are not mandatory, but certain points are mandatory that they need to be there explicitly. And I think if we promote such basic practices at a voluntary level, then we can see how it is. But I think the record says even with CCI and METI, again, I believe the CCI handles kind of better than METI on big tech, that big tech companies have not been able to even comply with the IT rules of 2021. So, and this is just like this has not been possible for them a lot of times. While with the debate on WhatsApp, encryption is a technological problem, and again, there is no legal solution to it. WhatsApp is WhatsApp. We can't do anything on that. So yeah, I hope that answered the question, but I love the question, by the way.
Yeah.
So, Brian?
Yeah. Any further questions, anyone? Suresh, sir? Okay, Navi sir, if no further questions are there, maybe I would propose a vote of thanks for Abhivardhan here. Abhivardhan, thanks a lot for opening this fascinating window to what looks like a bridge between science fiction and a scary scenario staring in front of us. And for a long time, those of us who are watching from the sidelines of whether we should deep dive into the EU AI Act and all, but looking for a opening into that, I think this session is very, very useful as to what all should an artificial intelligence law cover? I think many aspects you covered, for example, classification methods, registering and certification, registry of AI systems, and a national AI ethics code, and AI-related corporate governance, particularly, and incident reporting protocols. So these are all aspects that when we now examine any AI law or something, we'll definitely, this will become a kind of a template for us to evaluate whether the AI Act is comprehensive and covers all of these aspects or not. So thank you very much for sharing your thoughts. And I think it's a very bold attempt to propose a private act to at least the thought that somebody could come up with a private act and an attempt like this to regulate artificial intelligence is really a very, besides being bold, a very innovative one. Thank you so much. At least I enjoyed the session thoroughly and was very, very useful. Thank you.